Right, good morning everyone and welcome to today's session on 3 months to go, People and Skills. My name's Henrietta Brealey, I'm the Director of Policy and Strategic Relationships at the Greater Birmingham Chambers of Commerce and I'll be hosting today's session. I'm joined by Omer Simjee, who will be leading today really as our guest expert, looking into the EU settlement scheme, the UK's points-based immigration system, which is coming our way very soon, and in particular sponsor licences in relation to that. Before I hand over to Omer, I've got a little bit of housekeeping, a little bit of introduction from the Chamber. On the housekeeping side, the way we're going to run today's session is I'll shortly hand over to Omer to run through some slides, talk you through the fundamentals on those topics, but then we'll come back to this sort of screen and open it up so that everyone can have a conversation about the key questions that are relevant for your businesses, things that you're seeing in your organisations, and get a nice discussion going. While the presentation is going on, please do keep your mic on mute and pop any questions in the chat box, but you're welcome to open up mics to get to the Q&A to ask any questions you may have. Today's session is being recorded so that we can share it with businesses that were unable to attend but are keen to catch it. However, if there is anything that you'd like to ask that it's a bit more sensitive or private, flag it up and we won't include that in the recording. We really do want to make sure this is a nice open discussion forum for you guys so you can get the best out of today's session. In terms of the Chamber, most of you will already be very familiar with us, but for those of you who aren't, we're a not-for-profit business membership and business support organisation, and we exist to connect, support and grow local businesses. Through this particularly turbulent time, as we're managing through the impact of coronavirus, and now of course heading towards the end of the Brexit transition process, we've really been focused on how we can help keep business moving through a mix of support, information, engagement, connecting businesses to those opportunities that are available, public funded support that's out there, but also advocacy, representing businesses' views, shouting out on their behalf to local and national stakeholders. We have a range of other Brexit activity coming up over the next few weeks. As a quick overview, we've teamed up with Coventry and Warwickshire Chamber of Commerce, Country Chamber of Commerce and West Midlands Combined Authority on a range of different Brexit support and services. We've got some other digital workshops coming up. Namely Brexit in the services sector, data protection, implications there, steps businesses can put in place to make sure they're protected, and also imported goods on the 27th of October and more to come. We're also offering a range of training courses, so any businesses that are involved in the import and export of goods, it's well worth looking into these because these are fully funded training courses, completely free places, normally worth about £220 per delegate, on things such as the new border operating system, customs declarations and Incoterms. And we're offering a customs support helpline where you can speak to our international trade advisors and export documentation team who are particular experts in all things international trade about any questions you may have about what might change directly for your business in terms of documentation process and procedures as far as it is known at this stage. So that's what we've got coming up. However, on to today's session, we're really pleased to have Omer with us here today. Omer is managing partner and founder of Magma Legal. Omer's business immigration practice helps companies bring overseas experts to work for them in the UK, and he's built a really strong reputation supporting businesses and planning ahead to deal with Brexit-related staffing issues, and is also recognised in the Legal 500. He's also a member of the Chamber's Brexit Advisory Group that acts as a sounding board for us on Brexit activity and continues to be a really great advocate and advisor, helping us support businesses through this time. So we're really grateful to Omer for giving up his time and sharing his expertise today. That's more than enough from me for now. Over to you, Omer.
Thank you very much. Okay, just going to bring those, just bring the presentation, and Henrietta, can you see that okay?
I can indeed. I think everyone else can too. If you can't, pop a note in the chat.
Okay, great. Right, well, thanks everybody for attending today's session. Shame that we're having to do it in this slightly impersonal way, but thank you for joining nonetheless. And before we kick off, I just want to say that you should all give yourselves a big pat on the back for having the bandwidth to think about people and skills in 2021 with everything that is going on around us. So I think that's great, but I think what will also be clear from today's session is that an element of preparation and planning will go a long way. to help your businesses meet their resourcing needs next year. Right, well, the burning question at the moment, one I'm receiving the most is, can we continue to employ EU staff at the moment? And the answer is yes, you can, but things are about to change, and obviously that's why everyone's joined the session today, because we're all acutely aware that there's something approaching on the horizon, and we just want to identify what it is before it hits. But currently we have available to us the EU settlement scheme for EU workers. Now, this will remain active until June 2021, but only for workers who arrive in the UK before the end of this year. So that's extremely important to keep in mind, because what it means is that if we really fast track recruitment at the moment, and we were to bring in all the EU staff that we need to work in the UK, then we wouldn't need to necessarily have to worry immediately about the future immigration system, because we will have fulfilled our requirements, because the EU settlement scheme is certainly a lot easier to manage and navigate, and certainly from a cost perspective easier to manage and navigate than what is coming up on the horizon. So how's this settlement scheme been working so far? Well, the Home Office will tell you that 3.7 million applications have concluded so far. Now, that's not to say that 3.7 million EU workers have had their stay regularised, if you like, to be able to continue to work in the UK in the future. But a good proportion of the applications have been successful. But what really does put this into perspective is that freedom of movement will shortly be ending at the end of this year. There are no planned extensions to this, so we do need to think about, well, what will our staffing processes be for 2021, particularly because, and I give yourself a pat on the back for attending today, something that the government was talking about is no longer going ahead. So when I did this session about a year ago, we were talking about a route into the UK for low-skilled workers. These might be people high on experience, but low on qualifications. The proposed route has been abolished. So that makes it all the more important, I think, to either rely on the settlement scheme now or to slightly reconfigure your plans of who it is that you're going to bring into your businesses in 2021. In addition to which, if you're the type of business that relies on contractors, self-employed people, there is no dedicated route for them to enter the UK. So you're going to be looking at the other channels that we're going to be talking about in this session. So looking briefly then at the settlement scheme, before we go on to look at the future proposed routes. The settlement scheme breaks down into two categories, essentially. For those EU workers who are here and have been here for 5 years, in which case they can apply for something called settled status, or if they haven't been in the UK for 5 years, then they can apply for pre-settled status. Now, in practical terms, is there much difference between the two? No, it's the same access to benefits, it's the same access to public services. They both have the same rights to work for any company in the UK. The difference is really in terms of where these statuses lead you on to, because once you do have settled status, you are then en route to then applying for British citizenship and then applying for a passport in the future. So those who have pre-settled status, who've been here for less than 5 years, they will then go on to be able to apply for settled status in the future. So the takeaway right now, I think, is if you haven't done so already, support your EU workers in making these applications, because it will be a darn sight easier and less complex than what is approaching and what we're going to be talking about shortly. There's no cost involved. It can be done very easily. It can be done on an iPhone. It can be done on an Android phone, and it can be done quite quickly. So I think that is priority one. Make sure that your staff, that your EU workers are applying for those statuses at the moment. And then just practically, a right to work information. So you as employers, you'll be able to continue to accept EU passports and identity cards up until mid 21. But then I think just having in the back of your minds that I would expect at that point the government to issue a new List A and List B of right to work documentation, which will tell us how to deal with right to work checks after that, in terms of what we can accept and what we can't accept, and looking out for evidence of people who are in the UK with either settled or pre-settled status. Okay, so I mentioned earlier that there is no route into the UK for lower skilled workers come 2021. So what's the government's thinking behind that? The thinking is that they want you as employers to focus on staff retention for the staff that you have already, and they're thinking that as there are progress in the advancement of technology and automation, potentially your businesses will need to rely less on low-skilled workers. Well, I think, yes, there are certain businesses where that's going to work, but does it necessarily mean that a machine in a coffee shop is going to be able to replace a barrister in Costa? Quite possibly not. So yes, there are certain industries where that will work, and certain industries where we still want and need people working in those businesses. But then the government is saying, well, we've had great success with the settlement scheme. Look at all of those people that have applied, the 3.7 million I mentioned earlier. Well, they have now regularised their stay in the UK, so they are now available to UK businesses. Who else will be available? Well, potentially the dependents of skilled migrants. So, for example, it could be that we onboard in the coming years very skilled people. Well, they don't tend to travel alone. They may well be coming with their families, their dependents, husbands, wives, who will also be able to work in the UK. So that's a pool of people that will be available to us. And then agriculture has managed to carve out a little bit of a niche for themselves, an exception, potentially 10,000 places a year for seasonal workers. So I can just sense the relief amongst you that there will be people available to pick out strawberries for Wimbledon in the future. And then there will be a continuation of mobility arrangements with certain countries to allow young people to come back in the UK, typically for up to 2 years, without needing to be sponsored, without needing a visa. So again, they will be available to UK businesses, and there could be 20,000 young people coming to work in the UK who would be also able to work in your businesses. Now, let's start to look at the future points-based immigration system. So come next year, the same system will apply for people in France as it will in India, for example. Everybody outside of the UK is going to be treated the same. And the new system is going to be open for applications from January 2021. So what does this new system involve? What will you as employers have to deal with and think about when recruiting globally rather than just from the EU countries? Well, we are looking at a points-based system, and that means that your applicants will need to score sufficient points in order to qualify for a visa to enter the UK. And this is largely going to be based around having sufficient points scoring in areas such as skills and the entry salary. So let's look at that in a bit more detail. So we talked earlier about what the goals, low skilled labour. This future immigration system is about medium and high skilled labour. And I think that will come to make sense as we talk about some of the points-based requirements very shortly. So your starting point will be for recruiting outside of the UK. Your starting point is going to be, does the job I have pay a salary of at least £25,600 at least, and that minimum salary? Now, through work that has been done by the Chamber and other organisations, representations put forward by the likes of myself, the minimum salary for entering the UK has dropped from £30,000, which is what the government was first talking about, to £25,600. But it is a minimum. It is role dependent. So you need to establish whether the role that you have attracts a higher salary. For someone to come to the UK, they will need to be in receipt of a job offer from a licensed sponsor. So you will need a sponsorship license, and we're going to talk about what that means and how you can get one. The role itself has a minimum skills requirement, what the government calls RQF level 3. So RQF level 3 is basically A levels. So if you think about people from Europe and the wider area, you might have the equivalent of GCSEs. That's not going to be enough to score sufficient points. English speaking is something that I can see businesses overlooking, because I think it's easy to perhaps interview somebody over Zoom and think, yep, they're perfectly conversant, but that just because they can speak to you on Zoom doesn't mean to say that they will fulfill the English language speaking requirement. Either they will need to undertake a course that was taught in English, or they will need to take an English language test. Now, from doing many of these visa applications over the years, I can tell you from my experience that this is something to think about, because it could slow down your process. And one of the considerations I think you need to take away with you will be timing. There is a process that needs to be followed, and I'm going to be mentioning timing at many steps today. But if someone needs to take an English language test, typically in my experience, that can slow down your onboarding process by 4 to 6 weeks, because not only do they have to take a test, but then they have to receive the certificate after that. And then we need to establish whether or not the certification is going to be correct and sufficient. Now, I mentioned earlier a minimum salary of 25,600. Now, in this new world system, there is a little bit of wriggle room. So it could be that you are able to pay slightly less if your applicant is very highly skilled, or the job is in what we called a shortage occupation list. There is a lot of lingo to get your head around, but I'm afraid we're all going to have to get used to it fairly quickly. But having one eye on the shortage occupation list is certainly something that you need to remember and thinking about. I'm going to actually deal with now what the shortage occupation list is and why it's important. So when we are thinking about onboarding, we will go to the shortage occupation list to see whether the role that we have and we're seeking applicants for is on there. It will be to your advantage as businesses if your role is on there, because it will give you a points boost, and it means that you may well be able to more satisfy the requirements on onboarding your applicant. So let's put that in a bit of context now. Your target for your future applicants, for your future recruits, is 70 points. And how are we going to get there? How are we going to get those 70 points? Some elements are mandatory, but also relatively easy in the context of what we're talking about. Does your applicant have a job offer from you as an approved sponsor? So I mentioned earlier that all of you, your businesses, will need a sponsor license, but of course, let's assume that you have that. You make your job offer, that's 20 points in the bag straight away. Is the job at the appropriate skill level? Well, this is where the shortage, where the SOC code is going to be all important. I'm going to explain what that means. But once I've explained it and you've checked against it, this should be a fairly easy requirement. Just keeping in mind SOC. Is it at the appropriate skill level? I mentioned earlier, at least A levels. That's another 20 points. Does your applicant speak English at the required level? And I've talked to you about what that means. Okay, so that's 50 points that we have already from just fulfilling the basic requirements. We've then got to hit another 20 points. And I mentioned earlier, check the shortage occupation list, because if your role is in there, that's going to give you the remaining balance of 20 points. How else could we get there? Well, if you pay at the minimum salary that I mentioned earlier, 25,600, or the higher salary, if that's specified in the SOC, that could get you an extra 20 points. But in this new fluid system, how else might we get there? It might be that we pay a slightly lower salary because our applicant has a PhD in a relevant qualification to the role. So we could get 10 points from the education qualification. We could get another 10 points for having a slightly lower salary. So I think this particular slide is going to be quite an important go-to for you in order to do your homework in advance to see whether your applicant has the requisite 70 points, because no one's going to thank you and your organization is not going to thank you if you go to all the trouble of securing a sponsor license only to find later down the line that in fact your applicant is deficient on points in some way. Okay, so I've been asking you to look at your socks, and I'm not talking about the fine pair of black and white socks I'm wearing today. Your socks are your standard occupational classifications. Really important, because this is going to identify what qualifications your applicant needs. It's going to identify how much you're going to need to pay your applicant as a minimum. And I'll put the link there where you can find your socks. There's pretty much a code for every job you can think of. I'm going to talk about this in a bit more detail now, because it's very important in a number of different contexts. When you are looking at these different codes, do remember that there is some play in the system. I'm going to give you an example, live example of something I'm working on right now for a developer. Okay, this web developer potentially could fall in two different codes. Why is it important? It's important because one code attracts a lower salary than another code. Don't get fixated with the job title that is associated with the code. Below the code will be a description of what the job entails, and have a focus on that. And maybe even think about, in your pre-planning stage, building your job description around the code itself. I often tell my clients it's very helpful to take some of the language from the code description and to drop that into your job description. Because then when the Home Office is looking at the application, they can readily see, yes, we can see that that job fits into that particular classification. And what I'd also say is approach all of this with a bit of an open mind. There are very few people I've not been able to bring into the UK, but it's often the case that by just tweaking slightly something like salary or the job description, that you can find a way of bringing in the person that you want. Okay, looking next at some other practical considerations. I've talked about planning in terms of the job description. I've talked to you about timescales, which are very important to think about. Next, I want you to think about cost, because recruiting from outside of the UK is a costly business. And unfortunately, the government hasn't given any real concessions in this area. So two things you need to be thinking about in your planning stage. How much do you need to pay as an organisation to get somebody into the country? How much does the applicant need to pay to come into the country? Because if the budget holder in either of those two camps is to pay the associated fees, well, it's not worth going ahead then, is it? And it's not worth investing a lot of time and effort into this. Let's think about the employer charges. What I say to my larger clients is have in mind, if you're starting this process completely afresh and you don't have a sponsor license, have in mind a budget of about £3,500. Well, what is a large business? What is a small business? Typically, a small business is one with less than 50 employees and turnover of about less than 10.2 million. That's differential. What would be included in these types of employer charges? Well, you have your fee, fixed fee for your sponsor license. You will have then various fees that you need to pay to assign various things through the process. You also have your immigration skills charge, which is effectively an additional charge and tax which you need to, you'll need to pay in order to essentially support the visa. Let's just have a little think about that charge now, the immigration skills charge. You have a few options as a business. You can go straight in and try and get a 5-year visa. But what I tell my clients to do is to go with an initial 3-year visa and then extend that by a further 2 years. And I say that because the 3-year period gives them an opportunity to try out the applicant. And it all means that they're actually committing less cost up front. Because if you're a large employer and you've got to pay £1,000 a year for the immigration skills charge, well, that's a £3,000 charge you will need to pay up front when you're going through this process. So it's better to break it down in that way, to actually support an initial 3-year visa and then a supplemental 2-year visa. Those are your employer charges. What about the applicant? On how quickly the applicant. What you'll find in the lovely world of immigration is that everything can happen if you're prepared to pay a fee or a supplement. And you'll find to make things go just that little bit faster. Your applicant can potentially pay a premium application fee, which will fast track their visa. But they want to be budgeting if they're going to around about £1,500. Do they need to take the English language test? Additional cost. They also then need to pay a health surcharge, which is a levy charged on a per annum basis. So all in all, I tell my clients to tell the applicant that they need to budget around about £3,000 for their fees to come into the UK. And then there's a discussion to be had between the employer and the applicant about, is the employer going to cover those costs for the applicant? They don't have to, but quite often they do that as part of the overall package. What else do we need to think about? Well, let's look at this sponsor license. To be able to the UK. So really about some of the practical considerations about a sponsor license. Well, what is this license? It's not just something you apply for on a one-off basis and then you forget about. There is a huge amount of compliance that is required around the sponsor license. And why is that? It is to prevent people, employers, abusing sponsor licenses to bring people into the country who perhaps don't hit the points qualifications that we're talking about. So your primary consideration is who is going to be your authorising officer. This is really important because this person has their neck on the line if the licence is abused in some way. You will have your authorising officer who will be basically answerable to the Home Office. You'll have a key contact, and then you'll have a level 1 user who might just dip into and actually manage what we call sponsor management system. So acquiring your sponsor licence is giving you access to an acronym, sponsor management system. And you will hear a lot about people talking about the SMS. The SMS is basically your interface with the Home Office. It allows you to provide the Home Office with information about your employee and then continue to provide the Home Office with information. And it's that bit that employers often forget. They think just about bringing the person into the country, but it's not that. It's bringing the person into the country and then continuing to monitor that person and then continuing via this portal to give the Home Office information about that person. Are they leaving the country? Have they left your employment? Has the person themselves done something to breach their immigration conditions? You have to provide on an ongoing basis the Home Office with all of that information. And I keep coming back to this point around time. The Home Office will take around 8 weeks to consider your sponsor license, but there is a piece of work to do before that, which is to get the license itself. And that will involve a document collation exercise of providing certain mandatory documents. And I tend to say allow round about 3 to 4 weeks for this, because not only does all this information have to be collated, there's a letter that has to be prepared to go with it, which has to contain certain mandatory information. And then all of the documents, assuming that you're not providing originals and that you want to provide copies, all of that needs to be certified as well by an appropriate person, such as a solicitor. And then that needs to be sent. So the mechanism around this, by the way, is that you prepare and submit your application online as the employer, you pay your fee, and then you have 5 days to send all of your documents to the Home Office. And then again, whether you're a large or small employer, you'll either pay £536 or £1,476. What's the next step then? You've sent your documents, you've got your license. Well, what do you do with it? You then need to think about your certificate of sponsorship. This is a really important stage that is often not thought about and not planned for, in a sense, because the lingo is a little bit uncertain in terms of what employers actually need to do. This is your intermediate stage. Think about this as your stage 2, between your stage 1, getting your license, your stage 3, onboarding your applicant. This is the middle stage. what is a certificate of sponsorship? Okay, it's not a paper certificate, it is a reference number. It's a reference number that you generate that you will need to give to your applicant in order for them to come into the country. It's a number that they need to put on their application form. There are two types, restricted and unrestricted. And the easiest that I can make this for you is this. If you have somebody applying for a visa within the UK, you need an unrestricted certificate. If somebody is applying from outside of the UK, you will need a restricted certificate. And I can just sense you saying or thinking right now, Omer, we're applying, we're recruiting from outside of the UK, so why would I have an unrestricted certificate for somebody applying from within the UK? So it could be that your applicant is already in the UK working for another sponsor. And quite honestly, well, that would actually make things a lot easier for you. That person can make their application within the UK, and it will probably all take place a lot quicker than the alternative, which is somebody that doesn't have any kind of permission to be in the UK, who's currently outside of the UK. And it's for that cluster of person, you'll need a restricted certificate. Now, if you have an applicant who is outside of the UK, you need to factor in round about another 6 to 8 weeks in your onboarding process. That is because once you have your sponsor license, you will need to ask and request Home Office for a restricted certificate of sponsorship, restricted COS. You'll make that application and you will find out at the end of the month whether or not the Home Office is going to allocate that to you. And it allocates on the basis of the strength of the points of the applicant that has been scored. So you need to factor that into your. I talked earlier about the immigration skills charge, and then I talked about the third stage, which is the applicant travelling to the UK. And just a practical consideration there, in some cases, it is possible for an applicant to pick up their visa and their biometric residence permit from a post office in the UK. Just a practical consideration to think about there. Okay. All of that was about the sponsored entry route. Well, what about other routes to come into the UK? We have intracompany transfers. So this is where you will still need a sponsorship license, but it might be that you've got an overseas linked company, in which case you could just port somebody from that group company into your UK company, provided that you're going to pay them at least £41,500. Something is that that person needs to have been working for your overseas company for at least 12 months. Another route into the UK is graduate trainees. It could be that you have a graduate in the overseas company, you want to bring them into the UK to work, perhaps do a placement here for you. They can be here for 1 year. Other routes to the UK, non-sponsored routes. Business visitors, probably the most important here, can come into the UK for 6 months. The question I get a lot is, Omer, why should I bother getting a sponsor license when I can just bring somebody into the UK as a business visitor? Well, it's 6 months in a rolling 12 months, so it might not be long enough. And then secondly, and most importantly, they can only come into the UK to do certain permitted activities. It could be that they're on a fact-finding mission, that they're delivering training in the UK. It could be that you've bought a piece of machinery and you need the supplier to come into the UK and train your UK workforce on how to use that machinery. All of these are permitted activities as specified by the Home Office. Now, what's really important is that outside of these permitted activities, a business visitor cannot work, and certainly shouldn't be paid at all by the UK host company. So if you think about all of that, well, it suddenly actually reduces down the value of a business visitor. It can be a good, quick, easy solution to get somebody into the UK, and you will, I can guarantee it, be under pressure from those above you to bring people in as business visitors and have them do what you need them to do, even though it crosses the line of actually permitted activities and crosses into work. I would ask you all to push very strongly against that, because if that person is found by the Home Office to be working here in the UK, then it will be a black mark on their immigration record, and it will be a black mark on your record. Could stop that person coming back to the UK, and could stop you being able to sponsor people. I'm not going to focus much on global talent, other than to say it's a route for extremely talented people who are recognised in their field to come into the UK. And then looking at other possible routes, graduate routes, really important just to talk a little bit about the invaluable to you. This is actually 21, but I think it's something really important for you as employers to look out for, because basically international graduates from our UK universities will be able to work here in the UK for 2 years after their studies without needing to be sponsored. So currently they would need to be sponsored as soon as they come out of university. The future plan is that they would not need to be. So that's great. 2 years where they can work in the UK without being sponsored. Even better for PhD students who could be here for 3 years. That's the end of the session, and now happy to take any questions.
Fantastic, thank you, Omer. We're actually at the end of our scheduled session for today, but I'm really keen that everyone who's here who has got questions, who is encountering issues or questions within their organisation about this, has a chance to have them answered. So please do pop your questions in the chat while I do a very quick recap. So key points from Omer's presentation: support your EU workers in making their applications for settled and pre-settled status. Bear in mind there's an expected reduction in the availability of lower skilled workers coming as a result of the new system. And keep an eye on the detail. The new system will be role dependent. Do your homework before you go ahead with doing your sponsor license. Look at your SOCs and also your SOLs, your SMS, and costs both to you as a business and to the employee. Make sure those have been considered. English language test, key one to keep an eye out for, as it could trip up quite a few. And generally speaking, there are other routes that you can look at as well. The graduate route potentially is of interest for those entry-level roles in particular. And as Omer said, odds are you can always find a way. So if you're struggling, get some advice and see if there is a way of getting that role through. So in terms of quick questions, we've got one from James Roberts. Is there a ready list of shortage occupations, and will this be subject to regular reviews by government based on conversations with business?
Yes, if you follow the link that I referred to in the slide, on that you'll also find a list of shortage occupations. It will be subject to review by the government, and in fact, even over the last 12 months, there's been a lot of movement on that list, largely based out of conversations with businesses. So yes, you can rely on organisations such as the Chamber to continue to petition the government to review that shortage occupation list.
Brilliant, thank you. And I know we've done some roundtables with them in the run-up to the publication of this list, and we'll be continuing to engage directly and lobby through the British Chambers of Commerce as well, as you say. Thank you. Are there any further questions? Right, well, in that case, a very big thank you, Omer, for a very comprehensive look at the new system. I think there was a lot of really useful guidance in there for businesses. Do you want to leave us with your final piece of advice for businesses? What's top of your list for businesses listening? what's your one piece of advice of if you do anything, do this?
Planning and costs, guys. I think so important here. Do your homework, make sure that your applicant has the right number of points before we take the process any further, and also make sure that the FD is willing to pay the minimum salary required for the particular role.
Fantastic. Thank you again. As we say, the recording from today will be made available to you. So if you want to recap on anything that Omer said, we're also going to send out the slides so you can click through those links that he mentioned and get more information on these changes that will be coming our way. Thank you again, Omer. Thank you all for attending, and we hope to see you on a future webinar soon.